Hello friends, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we'll be discussing the topics of polity which has been in news in the last week. We'll be focusing on the static part. Also, we will be discussing the news, why these particular topics were in news and how these are important for our examination. So let's start. In today's video, we'll be discussing these 4-5 topics. One is related to your new criminal laws. Recently, you know that from the 1st July of 2024, we have started to go for the implementation of the new criminal laws, which is, when we are talking about earlier laws, there were IPC, CRPC, and then we had this Evidence Act, okay, Indian Evidence Act. Now they have been replaced with the new criminal law, so we will be talking about that. Then national party status, okay. So recently, elections were there, and otherwise also when we are talking about the various parties, there is one party that is BSP, okay. So actually there were chances that their national status might be, you can say, in doldrums. So we will be talking about national party status. Meanwhile, we'll also discuss the state party status, okay. We will see who provide this status, etc., etc., okay. Moving further, 7th schedule of the constitution. Recently, you know that because of the examination of national testing agency like NEET and etc., UGC NET, etc., so these subject of education was in news, and there were these discourses which were saying that there are people who are saying that the subject of education should be again put into the state list. Right now it is in under the concurrent list. So that is why we will be talking about what is this state list, concurrent list, or you can say union list, and we will overall we will be talking about the 7th schedule, okay. Then motion of thanks. The first session of the newly elected Lok Sabha was conducted, and every session or every new session, when we are talking about the new Lok Sabha, such sessions are addressed by the you can say president, and that is why we will be talking about the motion of thanks. After the presidential address, there is this motion which is passed by the you can say parliament. So since it is a joint session, so we'll be talking about the motion of thanks as well, okay. Now starting with the first one, that is basically Bharatiya Sakshya Act BNS 2023, okay. Since this act was passed in 2023, now the implementation has been done from the 1st of July 2024, okay. Now when we are talking about the Bharatiya Sakshya Act, earlier this was Indian Penal Code, okay, Indian Penal Code 1860, okay. So why did we go for the change? When we are talking about all these laws, all the 3 laws, IPC, CRPC, Evidence Act, these were the laws which were made by the colonial masters at that point of time when we were under their you can say rule. So basically we have actually gone for those laws. We have changes them time to time, but again there were various provisions which were of no use as of now, okay. So that is why we have gone for the change in this particular law, and we have tried to come out of the colonial legacy, okay. So when we are talking about the Bharatiya Sakshya Act, here you can say there is a change in the nomenclature as well. It was Indian Penal Code, okay, so that was talking about giving punishment, but when we are talking about Bharatiya Sakshya Act, that is talking about justice, okay. So that is the kind of you can say message we are trying to give, that our judicial system is not to punish, it is to reform, it is to give justice to you, okay. So that is one thing. BNS 2023 replaced the Indian Penal Code 1860, incorporating 358 sections, okay. Earlier there were 511 sanctions, so or whatever redundant sections were there, they have actually removed it, okay, and we have made certain changes in that. Now coming to the various provisions and the kind of offenses and the changes which has been made, okay. So first, if you are going for the false pretense of the marriage, or you can say if you are going for the false promise of the marriage and then you deny that, in that case, okay, that will be considered as the criminalizing deceitful promise to marry, okay. So wherein a woman can approach the court that this person was living with her for a long time on the deceitful promise of marriage, okay. So that is also criminalized now. Now moving further, mob lynching. When we are talking about the other earlier penal code, we did not have a particular provision for mob lynching, okay. Now we are codifying it as a offense, and there are certain you can say punishments up to life imprisonment or death that is also considered for it. Now moving further, ordinarily criminal law now covers organized crime and terrorism. When we are talking about the organized crime and the terrorism, specifically if we talk about the terrorism, we had this other acts, okay, like UPA, etc., but now they have actually put it under the ordinary criminal law as well, okay. So that will be there, including a broader scope for terrorism financing in BNS compared to UAPA, okay. You can go and read about UAPA because it was also in news because of the bail religion related provisions. And when we are talking about the PMLA, that was also in news because of the bail related provisions. Okay. Now attempt to suicide. When earlier when we see there are various times when the this status of the attempt to suicide as a crime was changed, but this time here you will see they have criminalized the attempts to commit suicide with the intent to compel or restrain any public servant from discharging their official duty. So if there is a public servant who is discharging their official duty, or otherwise let's say for example a civil servant is coming to you to arrest you, but now you are threatening them with the suicide. If someone tries to arrest that particular person is threatening you to go for a suicide. Okay, so such particular threat will be considered as a crime. Okay, so that is their attempt to suicide against a public servant, or trying to stop a public servant from discharging their duty. That is a crime. Now then coming to the community service. Earlier when we are talking about the various provisions, we did not have the provision of community service. This is kind of a western you can say idea, wherein in the western jurisprudence there are certain acts, or you can say certain lower degree of crime which are put under the, you can say, provision, and there is a provision of community service because if the degree of the crime is less, in that case you don't have to go for any kind of imprisonment, you can go for the community service. By community service here we means that you will be asked to do certain service to the some kind of NGO or any kind of social service they would ask you for. Okay, why we have gone for this particular provision? Because the thing is, when we are talking about this lower degree of crimes like small theft, etc., going for jail or you can say imprisonment, there are certain social stigma attached to it. Okay, other than that also, a person who is going to jail, he has to live in a certain environment where all the criminals are living. Okay, so if let's say a first time thief is there, so that person can have this opportunity, can be given an opportunity to reform himself, and that is why this community service is given. Other than that, one more thing is there, our prisons are very crowded. Okay, so to avoid that overcrowding, we can go for the community service. Okay, that is there. Other modification if we talk about, so fake news, there is this criminalization of the publishing fake news and the misleading information. Other than that, sedition, earlier that sedition laws were there, and now they have actually changed the nomenclature. They have covered it under the Deshdroh, and actually they have made a broader definition of that. So that is there. You can say the section related to sedition has been removed, but that crime basically has been covered in Deshdroh. There is another section with respect to that. Now mandatory minimum sentence. Okay, and then other than that, you can say damage to the public property, death by negligence. Such things has also been discussed when we are talking about the you can say the current Bharatiya Nyaya Sanhita. Okay, so that is about it. Now moving further, here you will see certain things has been deleted, that is unnatural sexual offenses, section 377. When we are talking about the 377, there was this particular section which has been decriminalized by the Supreme Court, but in this particular, you can say, Bharatiya Nyaya Sanhita, actually they have altogether removed the section 377. But the thing is, there are certain concerns when we are talking about removing 377. There is this prejudice against the men. Okay, so earlier if there is an you can say non-consensual sex with a man, in that case you can go to court with respect to section 377, but now that has been deleted. But there are talks that it might be added soon. Okay, so that is another thing. Now adultery, that is also offense of adultery omitted in the consonance of the apex court judgment. So that court judgment was there. Then section 310 that was fully omitted related to thugs. Okay, at a particular point of time India has witnessed these thugs, but the thing is now we don't have it, so we have omitted it. Okay, now gender neutrality, some laws dealing with the children modified to be gender neutral. Okay, so they have changed the terminology to make it gender neutral. Okay, so this is about it. Now moving further to the next one, that is Bharatiya Sakshya Act 2023. Okay, or Bharatiya Sakshya Adhiniyam 2023. Now this is basically relating with the evidences. Okay, how evidences will be read, how evidences will be having a particular importance attached to that. Okay, so that is there. The Bharatiya Sakshya Adhiniyam 2023 has 170 sections, altering 24, adding 2 and repealing 6 of the 177 section of the Indian Evidence Act. So basically it is replacing the Indian Evidence Act which was earlier there. It is from the 1872. Okay, now again, since it is 1872, it is also a colonial law. Okay, but now we have gone for the change. Now we will see the provisions. Key changes if we talk about, first is electronic record holds equivalent legal status to traditional paper document. Earlier when we are talking about the electronic records, since when we are talking about the law, when it was made, there was no electronic record per se. But the thing is, with the time, there were certain things, some certain scientific changes which has happened, because of which technology's use has increased, and that is why these digital, or you can say electronic records, were also being the part of evidences. Okay, but now with this particular change, they have actually given the equal or equivalent legal status to the document. If you have a physical document, similarly, if you have a evidence which is electronic evidence, so they will be having a equal status. Okay, electronic records encompasses data stored in the memory and communication devices. Okay, so basically here, if you had the WhatsApp chat, etc., so earlier those were basically collaborative evidences, but now that has been given the legal status, or you can say equivalent legal status to a document. Then allows oral evidence to be given electronically. So basically, with the help of the video chat, etc., you can take evidences. Okay, now moving further, electronic records are categorized as the secondary evidences. Okay, so when we are talking about the secondary evidence and the primary evidence, when we see, so basically that is evidence which can be considered when we are talking about this paper documents and the let's say murder weapon. So these are primary evidences. Okay, electronic evidences are categorized as the secondary evidence. Now a joint trial means trying more than one person for the same thing. So now we have this provision of the joint trial as well. A trial of multiple persons where an accused has not responded to an arrest warrant will be treated as a joint trial. Okay, again, a trial of multiple persons where an accused has not responded to an arrest warrant will be treated as a joint trial. Okay, so basically here we are saying that there will be a trial of multiple persons which is allowed in that particular thing. Okay, now key issues, if we see, when we are talking about the electronic record, first of all, the issue is that we need to develop that kind of infrastructure. Okay, second is concern regarding the tampering of electronic evidence during the search, seizure and investigation process. Okay, since these are electronic you can say evidences, so you know that there can be hacking, there can be intrusion of the privacy, etc. Such things can be happening. Then usually electronic record must be authenticated by certificate to be admissible as a document. The Act classifies the electronic device as a document which may not need certification, creating a contradiction. Now the thing is, earlier there was this you can say certificate of admissible document was to be presented, so that you can see some of the electronic evidences can be authorized in the court. But the thing is, here in the Act they have said that this particular document need not to be certified. Okay, so that is there, because of which there can be contradiction. Okay, now exclusion of the suggestions of the Supreme Court and law commissions. There are certain judgment, there are certain law commission recommendations which were made during the, you can say, changes which has been made in this Bharatiya Sakshya Adhiniyam. So those recommendation has not been recognized. Okay, so that is about it, but that is not a new thing. When we are talking about the legal commission, law commission, that is basically an advisory body. So taking their recommendation or not, that is, you can say, prerogative of the government. Now moving further, here you will see Bharatiya Nagrik Suraksha Sanhita, BNSS. Okay, again it is related to your when we are talking about the criminal procedure in a country, when we are talking about any particular crime which is happening, from that particular time to the registration of FIR, the arrest, then investigation, and then when we are talking about the judgment, etc., there is a particular procedure which has to be followed. Okay, that is basically we used to follow this Criminal Procedure Code 1973, but now that has been replaced with the Bharatiya Nagrik Suraksha Sanhita. Okay, so that is BNSS 2023, and it will be consisting sections 531 sections were there, with 177 sections revised, new sections which has been added, and 14 sections which has been repeated. Okay, but again you don't have to remember all these things. Okay, but the thing is, just remember that nearly 531 sanctions are there, and BNSS has replaced the CRPC. Okay, now what are the key provisions? Okay, so hierarchy of court that has been, there are certain courts like Metropolitan Magistrates Court, so they have actually eliminated and distinct role of these Metropolitan magistrates. Okay, then mandated use of electronic modes. Okay, so basically when we are talking about any kind of event which has happened, and that is a part of a crime, so basically filing of FIR, and after that all the investigation, evidence gathering, etc., which is happening, so there is this use of electronic mode that has been mandated now. Okay, detention of the under trials. Okay, restriction on the release of personal bond. So when we are talking about the arrest, there are certain provisions like bail provisions are there, and there are bond provisions, etc. So actually here it is said that the detention, or you can say restriction on the release of a person, on the personal bond or an accused person, that has been actually made limited in the case of a person who is charged with the life imprisonment and the facing multiple proceedings. Okay, so basically if a person who is charged with you can say life imprisonment, or if they are facing multiple you can say cases, in such case you cannot release them on the personal bonds. Okay, so that is there. Third is alternative to arrest. Okay, if there is a possibility that a person should not be arrested, and you can say you can go for signing you can say you can sign for the security bond, okay, in front of a magistrate. And the thing is the condition will be that whenever this person is required by the law or the court, he has to be present over there. Okay, so that is there. So that is an alternative to the arrest. Now why we are trying not to go for arrest? Because again, as I told you, under trials also has to be sent to a jail, and again our jails are overcrowded. Second thing is, when we are talking about the under trials, okay, they are you can say whatever charges which has been made, that conviction has not been given yet. Okay, so if an innocent person is being arrested and he is kept under the jail, and again, even if he is not convicted, again he has spent some time in the jail, so you cannot actually replace that particular time. Okay, so that is why that is there. Now community services, as I already told you earlier, we did not have this provision of community services, or you can say any kind of social service which has to be provided by the accused, and so that he does not have to go to jail in the case of your lower degree crimes. Okay, now substitution of the terminology. There was this term earlier which was used in the various provisions, that is mental illness. Now that term has been replaced with the unsoundness of mind. Okay, so that is there. Documentation protocols. So there are, when we are talking about the searches with or without warrant, require mandatory audio video documentation, and which has to be put forward in front of the magistrate, okay, as early as possible. So basically what they are saying is that if there is an evidence recording or evidence gathering, okay, let's say if there is a crime scene from there, you are gathering their evidences, so you have to document it with a video camera, and the audio should also be recorded, and then it has to be submitted to the magistrate. Okay, moving further, here we will say timeliness of the procedure. Earlier when we are talking about, there is no this hard and fast rule with respect to time. Now they have said that within issuing of the verdict, you have, after this the arguments has been put forward in front of the magistrate, within a particular time period you have to give the verdict. Okay, so that is you can say a kind of a term or the condition which has been put on the judiciary. Okay, medical examinations, so that can be requested by any police officer in certain particular case. Sample collections, so when we are talking about certain samples like you can say some signature, specimen, etc., magistrate can compel individuals to submit signature, specimen, handwriting of samples, etc., if they haven't been arrested. Okay, so that is there. Forensic investigations, if there is a provision for imprisonment more than 7 years, okay, in that case it is mandatory to go for the forensic investigations. Okay, then new procedure with respect to FIR registration. So when we are talking about FIR registration, they have gone for the electronic registration of FIR, online registration of FIR. Then you can say zero FIR can also be filed. When we are talking about the zero FIR, that means that if the crime has happened in particular jurisdiction and that person is going to another jurisdiction of a police station and he is filing the case over there, at that point of time, these people or the police officer at that point of time will not actually give a serial number to the FIR. Okay, that is why it is called as zero FIR, or the serial number there will be 0. After that, this particular case will be sent to the station which is actually having the jurisdiction, and there it will be given a, you can say, maybe serial number. Now zero FIR example can be seen. Let's say if a crime has happened in Jodhpur, okay, and a person that, or the victim, has gone to Delhi and they have filed an FIR to Delhi. Okay, so earlier that was not the case. Okay, not only when we are talking about this BNSS or CRPC, even in CRPC earlier it was not the case, but later it was added on. Okay, when we are talking about this particular case wherein crime has happened in Jodhpur and that FIR has been filed in New Delhi, so that is the kind of FIR which is called as zero FIR. So FIR can be filed without jurisdiction of that particular police station, but again they have to send the case to the relevant police station afterwards. Okay, so that is about the provisions of your new criminal laws which we have seen. There are certain concerns as well when we are talking about the new criminal laws. There are certain states which are saying that the custody time, that 15 days custody has been actually expanded. They have said that that 15 days custody can be given to 16 to 90 days, 60 to 90 days in the time period. In that particular time period, any time if police wants, they can take the custody of that particular person for 15 days for the investigation. Why we have gone for this particular you can say provision? Because when we are, let's say for example, there is a provision of police custody for 15 days, but that particular person was hospitalized during that particular 15 days, okay, then police will not have the authority to go for the police custody afterwards, okay. That is why they have said that within 60 to 90 days they can go for the police custody, okay, but that custody would be there for only for 15 days, okay. Other than that, also there has been some requirements of the preliminary investigation when we are talking about the filing of the FIR, okay. So they have said that in case there is when we are talking about the nature of the crime is not clear, okay, so that in that particular case you can go for the preliminary inquiry for 14 days, okay. But now that police can go for the, you can say, preliminary investigation for 14 days in any case, okay. So that is there. Other than that, some states are saying that the provisions, or you can say these codes or the nomenclature of the codes is made in Hindi, but again the Home Minister has clarified that it will be given in various local languages as well, and that will be practiced in that particular local language, okay. So these are the certain things which we have already talked about, these you can say criminal laws. There are various aspects, but it is kind of you can say glance from the week, so you can go through this. Now moving further, that is next is national party, or you can say status of a national party. And when we are talking about the national parties, we can also talk about the status of the state parties, okay. So who gives this status? Why it was in news? Because recent elections were there. When we are talking about India has 6 you can say national parties, okay. We will be talking about that. So recently one of the that particular party is on the verge of losing that national party status, so that is why we have taken this particular article, okay. So let's start. Now if we see the first one, the ECI has laid down the technical criteria for a party to be recognized as a national party or a state party, okay. So when we are talking about the national party and the state party, there is this law, election symbol and reservation and allotment order 1968 as amended from time to time, okay. So 1968 we have come up with a particular order, that is election symbols, reservation and allotment order. So basically ECI, under this particular order, they grant the status of a national party or the state party. A party may gain or lose national or state party status from time to time depending upon the fulfillment of the requirement laid under this particular law. Now what are these requirements? So here you will see criteria for a party to be recognized as national party. Now this all criteria you should remember, okay. So start. A political party would be considered as a national party if it is recognized in 4 or more states as a state party, okay. That is a simple provision. If you are a state party in 4 or more states, then you will be a national party. Or if its candidate polled at least 6% of the total valid votes in any 4 or more states in the Lok Sabha or assembly elections, and at least have 4 MPs in the last Lok Sabha poll. So basically either you have got the 6% of the valid votes, okay, so that is one thing. Along with it, in the Lok Sabha or assembly elections, and has at least 4 MPs in the Lok Sabha polls, okay. So here one thing is clear, that if you are getting these 6% of the votes, that is in the 4 or more states, otherwise also you have this 4 MPs in the you can say Lok Sabha. So this is the second criteria. Then third is if it has won at least 2% of the total seats in the Lok Sabha from not less than 3 states, okay. So in the Lok Sabha election you have got, you can say, at least 2% you can say seats, 2% of the seats, and not less than 3 states, okay. These are the 3 conditions which are basically you can say you need to fulfill any one of them so that you can be a national party. Now in India, if we talk about BJP, Congress, CPIM, Bahujan Samaj Party, that is BSP, National People's Party NPP, and Aam Aadmi Party, these are basically you can say your national parties, okay. Now moving further, here criteria to be recognized as a state party. Here you can see, we have seen that here, if a party is recognized party, or you can say state party, in 4 or more states, okay. Now we will see how you can determine a state party status, okay. To be recognized as a state party, a party need to have at least 6% vote share in the last assembly elections and have at least 2 MLAs, okay. At least 6% vote and 2 MLAs. Second is have at least 6% share in the Lok Sabha elections from last states and at least one MP in the state. Okay, so either you are having 6% votes in the assembly elections and 2 MLAs, and otherwise you are having 6% vote share in the Lok Sabha elections plus 1 MP of that from that particular state. So these are the, you can say, criteria. Other than that, we have at least 3% of the total number of seats or 3 seats, whichever is larger. Okay, again 3% of the total number of the seats and 3 seats or whichever is larger in the last assembly elections. Then at least 1 MP from every 25 members or any factions allotted to the state in the Lok Sabha elections. So when we are talking about Lok Sabha elections, so at least 1% MP for every 25 members should be there. Okay, so that is about the other condition, and have at least 8% of the total valid votes in the last assembly elections or Lok Sabha elections from the states. Okay, otherwise all these conditions you are fulfilling, any one of the condition you are fulfilling, or else you have to fulfill this particular condition, that is basically at 8% of the total valid votes in the Lok Sabha or the assembly elections. Okay, I hope that is clear. I know it is a bit difficult to remember all these conditions, but again this is what it is, you have to remember it, nothing you can do about it. Okay, now moving further to the next part, that is what are the benefits. Okay, so when we are talking about the national parties and the state parties, there are certain things which you can get out of it, there are certain benefits with respect to that. So that is basically, if you are a party which is recognized as a national party, it is entitled for exclusive allotment of the reserve symbol to the candidates throughout India. Like let's say if we are talking about BJP has a particular election symbol that is of a lotus. Okay, so throughout India BJP has the same symbol, so that is the, you can say, benefit of being a national party. Second, recognized state and the national parties need only one proposer for filing the nominations. When we are talking about the nominations, for various requirements are there. Okay, one of the requirement is that if you are a national and the state party, only one proposer is needed. Okay, they are also entitled to 2 set of electoral rolls. If there is a change in the electoral roll, so party will be getting 2 sets of that out without any kind of fees. Okay, and their candidates will be getting 1 role each at the time of the general elections. Okay, so that is there. Other than that, further they get broadcast and the telecast facilities over the Akashvani and the Doordarshan. These are the, you can say, channel which are owned by the state. Okay, so on that you will be getting a time for the broadcast and the telecast. A recognized national or state party can have maximum of the 40 star campaigners. Okay, so that is also you can say benefit, you are getting 40 star campaigners. Okay, so that is about these benefits. Now we can move to the next one, that is related to your 7th schedule, because recently there was this issue of you can say integrity of a particular institution which is going to conduct certain examination, that has been compromised for some reason, and now because of this there is this topic of discussion, that is education should be sent back to the state list. Okay, right now it is in concurrent list and it is to should be transferred to the you can say state list. Okay, why is that? When we are talking about the state list, state will have an exclusive right over the making laws in that particular department, I mean on that particular subject. And when we are talking about the concurrent list, in the concurrent list both state as well as the center can go for the making of law, and the law which has been made made by the center, that will have a prominence over here. Okay, so that is why they are saying that it should be kept out of the current concurrent list and sent to the state list. Okay, so that state can have a more say. Okay, now let's talk about education as a subject first. So when we are talking about the education as a subject, in 1935 Act, Government of India Act 1935, you know that there was this federal structure which was started in India, and at that point of time though 2 lists were made, that is one was federal list, second was the provincial list. At that point of time this topic of education or the subject of education was kept under the provincial list. Okay, after that we have won our independence, and in that particular time also we kept the education in the, you can say, same provincial list or the you can say state list. Okay, furthermore in 1976 when we are talking about the you can say Swaran Singh committee came, and Swaran Singh committee has recommended that the topic of education should be sent to the concurrent list, and with the 1976 Act, that is 42nd Constitution Amendment Act, with that they have sent it to the, you can say, concurrent list. After that you know that there was this emergency sector which was happened, and then in 1978 we have this 44th Constitution Amendment Act, that was actually initiated by the Janta government, and they have tried to reverse all the changes which were made by the 42nd Constitutional Amendment Act, but they could not actually change this particular part. So the subject of education stayed in the concurrent list. Okay, and now recently again there was this you can say discussion which has started to send it back to the state list. Okay, now what is 7th schedule? What are these lists? Okay, so when we are talking about the 7th schedule, in the 7th schedule there are, you can say, 3 lists. Okay, list 1 is basically related to your union, then we have state list, then we have concurrent list. Okay, so basically when we are talking about the union list, the power of making laws is with the center. Okay, so center can make laws in the, you can say, union list. Then when we talk about the state list, the power of making laws vests with the state until unless state by themselves ask parliament to make a law. Okay, third is the concurrent list. In the concurrent list, both state as well as the center has power to make a law on a particular subject. In case of the contradiction, if there are 2 laws, one has been made by the state, one has been made by the union, in that case the union's law will prevail. Okay, until unless that particular state is going to president and getting assent for that. Okay, and if the presidential assent has been given to the state, then in that particular state, that law which has been given the presidential you can say assent, that will be operative. Okay, so that is about the concurrent list. There are certain residual subjects which are to be made law by union government. Okay, now let's talk about certain provisions when we are talking about this particular list. Okay, so we have article 246 of the constitution, which talks about the, you can say, division of the power. Okay, and that is saying that there are 3 lists which has been given in the 7th schedule, and accordingly the power is divided to make law. Okay, so coming to the 7th schedule, the 7th schedule of Indian constitution specifies the allocation of powers and functions between union and the states. Then there is this article 246 in the constitution, which is under 7th schedule of the Indian constitution, demarcate the legislative power of the union and the state. It divides the subject matters of the law made by parliament and the state legislature under the 3 lists, that is list 1, that is union list, then we have second list, that is state list, and third list, that is concurrent list. To amend the 7th schedule of the Indian constitution, a special majority of parliament and ratification by the half of the state legislature is to be there, and that ratification can be with a simple majority. But when we are talking about this you can say passing in the parliament, that should be special majority. Okay, and speaking about this half of the state legislative by a simple majority's approval, that is kept because this particular provision is a federal provision. You can say it will impact the federal structure of the country, and that is why in such cases such half of the state legislature approval is required. Okay, so that is there. Now moving further, here you can see this is the 7th schedule. There are 3 lists. We won't be going to in details of these subject matters, because obviously there are various subject matter. When we are talking about the union list, there are nearly 100 subjects. When we talk about the state list, there are nearly 61. When we talk about the concurrent list, there are nearly 52 subject matters which are there. So all of them are not necessary. When we are talking about the union list, you can see defense, banking, currency, foreign affairs, communication. These are the important subjects which are with the, you can say, central government. Then when we are talking about the state government, the police, trade, agriculture, irrigation, these are with the state governments, and these are basically in the concurrent list. Okay, so that is education, forest, trade, marriage, adoption, succession. These are basically in the concurrent list. And in this particular area, you can say even central government and the state government, both of them can make particular laws. Okay, this is what has been written over here, which we have already discussed, so you can go through it. Okay, now moving further here, next is basically related to your presidential you can say address and the motion of thanks. Okay, recently that new Lok Sabha has been constituted, and they have assembled, they have gone for the, you can say, elections of the speaker, and after that there was this presidential address which has happened. Okay, once president give the address, president is basically telling the members about the plans and the goals of the particular government, and that has to be passed by the parliament. Okay, so there will, after this particular address, there will be a motion of thanks on that particular address, and ultimately this particular motion of thanks has to be passed by the parliament. Otherwise there are chances that you will it is indicative of one thing, that is you have lost the confidence. Okay, so that is why if you are not able to get it passed by the parliament, that means that you have lost the confidence and the government may fall. Okay, so that is about the importance of the presidential address and the motion of thanks. So let's start. Article 87, 2 special occasions are there when president can address a joint sitting. Okay, president will be addressing a joint sitting. First is the proclamation during the inaugural session of the new legislature after the general elections of the Lok Sabha. So every time there are new elections or the general elections, new Lok Sabha is assembling, then president will go for an address, okay, to the joint session. Both the you can say house of the parliament will be sitting together. Then a session of new legislature can not commence without completing the proclamation, okay. So this particular thing, as I told you, first sitting of this new Lok Sabha, that is the time when president can be giving an address. Second thing is every years the first session will be there, and that time also president will actually address the parliament, okay. Proclamation during the first meeting of the parliament each year. Every year the first meeting will be addressed by the president. Now a session of new legislature cannot commence without the completing this particular proclamation. So that is the thing, for every new session there should be you can say this particular address, okay. Now moving further here, you will see about the presidential address history if we talk about. So it started from the, you can say, United Kingdom in 16th century. At that point of time, the king or the, you can say, monarch will be addressing the parliament, okay. After that, when we talk about United States of America or USA, in 1790 there was this address, presidential address, the Congress, for the first time in 1790, and after that become a you can say tradition over there. When we are talking about India, so the practice of presidential address in the parliament was established in 1919 Act, okay, which is your 𝐈𝐀𝐒 reforms. At that point of time, what happens that in the, you can say, 1919, they have come up with the you can say this particular provision of the diarchy, okay. At that point of time, you know that there was this particular you can say the post of president and the deputy president was also started, okay. There were two houses, okay, and that point of time that particular houses used to be addressed by the governor general, okay. So that was the criteria at that point of time. After that, in Government of India 1935 Act, the you can say names of the president and the deputy president has been replaced with the speaker and the deputy speaker, and that criteria was there that there will be a, you can say, address by the governor general, okay. After that, we have talked about the independence. When we come up with the, we have won the independence. At that point of time, Dr. Rajendra Prasad, he has addressed, okay. And furthermore, if we see when the government was made, okay, so he has gone for this particular, again addressing the you can say parliament, and after that there was this law which was made, and this has become the law, okay. So after, at the time of the 1990 Act, there was this Governor General of India, Governor General of that particular province, and at the, you can say, center India, they used to go for the, you can say, this address. After the constitution came into force, President Rajendra Prasad addressed the Lok Sabha and Rajya Sabha for the first time in January 31st, 1950. Later on, there was this you can say provisional parliament was there in 1950. At that point of time also, President Prasad delivered a speech before each session. And in 1951, with the First Amendment Act, the Constitution made this law and made the President's address as an annual event. Now, what is motion of thanks? Once this address is given, after that there will be a motion of thanks which will be put forward in the table of the Parliament, and then there will be voting, etc. So let's see. The motion of thanks is parliamentary procedure in which a formal motion is presented to express the gratitude or the appreciation for the President's address to the both the houses. Once the motion is presented, then there will be debate on the address, then there will be reply by the Prime Minister, and then there will be voting on the motion, okay. Now on the voting, it is imperative that this motion is passed, otherwise there will be this you can say indication that the you can say the government has lost the confidence, and that is why government may fall as well, okay. So that is about the, you can say, motion of thanks and the presidential address. As usual, we'll be discussing 4-5 questions will be there for you to answer. You can answer these questions in the comment box, and let's start with the question number 1. These questions are basically related to the topic which we have already discussed now. Which new legislation replaced the Indian Penal Code (IPC) in India? Bharatiya Nyaya Sanhita, Indian Penal Amendment Act, Bharatiya Suraksha Sanhita, Indian Penal Code 2.0. Okay, so you can go through the option and the reply me in the comment box. Okay, now talking about the question number 2. In case of conflict between union and the state laws on subject in the concurrent list, which law prevails? State law, union law, law passed first, law passed later. Okay, that is there. You can answer that. Now, question number 3. What happens if the motion of thanks is not passed in the parliament? A. The president must resign. B. It is considered a defeat of the government and may lead to the resignation of the Council of Ministers. C. New elections are called immediately. D. Speaker of the House is removed. Okay. So basically, you can answer that. Now moving further, question number 4. Which of the following party is currently a national party in India? Communist Party of India, Marxist, Aam Aadmi Party, Bahujan Samaj Party, all of the above. Okay, so you can attempt that question, and that would be all for this episode. I'll be seeing you in the next week. Till then, have a good day. Thank you, and if you have not subscribed the channel, please subscribe it.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.